Hello and welcome back to Learn Law with Hannah. Thank you for all your comments. Please keep them coming. And in response to one person, no, I haven't had a facelift, although I think they said facelifts, plural, no facelifts. Okay, so week 7 of the Letby trial. Now on Monday they were not in court because there was an ill juror, but the juror was well enough to be back in court on Tuesday. So the trial resumed on Tuesday, and this week they focused on child F. Now child F did not die, so the charge against Letby for child F is attempted murder. Watch my short on the definition of attempted murder. So this all focused on the blood sugar level of child F. It was very low and child F had a high heart rate. The parents wanted him moved because child F is the twin of child E, and child E had died, but there was no transport available to move child F to a different hospital. Lucy Letby sent a text to a colleague about child F being a worry, and later had a text back to say that child F was better. Now, a lot was made of the fact that Letby messaged a colleague to say that she needed a break, it was her evening off and she was going salsa dancing. That in itself, I mean, some people might think, oh, a child has just died and she's going on a night out. Well, in her job, children are going to die. In lots of people's jobs, bad things happen, and you are entitled to your right to a private life. So I don't think that is of any significance personally, that she went on a night out or went salsa dancing. Now, Letby is alleged to have added insulin to child F's intravenous feed bag, and only a small amount was actually needed to correct his blood sugar level. They also said in court that she had a text message about viewing a house. Again, relevance of that, not quite sure. Let me know what you think. So this really kind of focused on text messages with the colleague, the house text, the salsa text, and Letby did search for the parents on Facebook. Again, I mean, significance of this, it's probably not the most professional thing to do, but that does not mean that she is a murderer. Letby texted her colleague and said that child E and F's parents had come into the hospital. The colleague told her how she had done her job to a very high standard and that she was very professional. The parents actually brought in a hamper for the hospital to say thank you for all of their help and support. On Wednesday in court, 3 other nurses denied giving any insulin to child F. And then Thursday focused on some evidence from a doctor. And then on Friday, focused on evidence from a professor. Now, in terms of things they were saying, some of the highlights of their evidence in court, one of the doctors said there were no other babies on that ward that needed treatment and had any insulin, so it couldn't have been accidental. So child F had received a very fast acting insulin and had very high blood sugar, had responded well to the insulin, also being treated for suspected sepsis, and in the night was sick, had a heart rate of 200 beats per minute. Now, child F, they found, had very, very high levels of insulin. The professor in court said it could only have been done deliberately, and it was just too high to be accidental, and it was very suspicious, so poisoning was the only option. So in summary, child F's harm, injuries, I guess we can call them, could not have been accidental. As of yet, I don't feel that they have placed Letby at the scene. I mean, yes, she was there, but I don't feel that we can be sure, beyond a reasonable doubt, that Letby was the one that administered the insulin. But the trial will continue next week. It's still the prosecution, so we have a long way to go before we hear the defence KC. Whether Letby will give evidence is going to be very interesting. I think her KC would have advised her to do so. It doesn't look good if you, the defendant, don't give evidence in court. But keep the comments coming. Any questions about the law, please ask. And yeah, hit like and subscribe.